Good evening and welcome to the first evening session of Advanced Entertainment Law here during this May term. Hopefully everybody had a good, safe, and happy April. If you are in a location that is in that reopening phase, hopefully things are going well and moving forward. Tonight we are going to focus in our first evening session, of the term. We are going to focus on intellectual property related to your business. For my cohort that would traditionally be physically on campus, this morning we had our first virtual session and we were talking a little bit about our courts, and I mentioned that our courts were doing virtual sessions. Just as a heads up, if any of you are giant fans of the law like myself, you can actually go back and listen to the 1-hour session that occurred earlier today dealing with a trademark dispute with a brand that allegedly was not distinctive. So our Supreme Court did a virtual hearing earlier today where you could go through and hear both of the parties arguing in front of the 9 justices. So know that we are all moving through this very interesting time in history. But with that being said, just full disclaimer for my online cohort, just kind of getting to meet and greet you for the first time tonight. My name is Cassie Willard. I know some of the platforms in some places have my formal name, Cassandra. I go by Cassie, so no worries there. I am an entertainment attorney here in Central Florida. I have been the head of the Entertainment, Art, and Sports Law section of the Florida Bar twice. Over the past decade, I serve as the head of a National Entrepreneur Center business community partner. So I actually serve with an organization that works with entrepreneurs here in Orlando. We're a local chapter of a national organization. So needless to say, I've been following a lot of things closely. I've heard from the folks that are online who got here a little bit early, amazing things that they've done to prepare for success later tonight in the form of dinner, as well as some different cool projects that they worked on throughout the day, just being very productive. I have watched a tremendous amount of press conferences because I've been paying a lot of attention as far as what the reopening is going to look like, how it's going to impact our local small businesses statewide as well as across the nation. So I can watch press conferences, I can watch judicial hearings. I am hardwired to live in this space of business and law. So good, bad, or otherwise, I just embrace the fact that I love this space. But tonight, for our first session, we are cannonballing into intellectual property, which is exactly what our Supreme Court was focused on today, specifically looking at trademarks were their main focus. But with that, just so you know, kind of the structure of these evening sessions is we'll go through for around an hour and talk about the content of the session. And then at the end of the session, the last 15 minutes or so, we're really going to do a dive into the upcoming assignments for this next week. So I want to make sure that you have the tools and you're set for success. It's important to do this. So we're going to roll up our sleeves, look at this content first so you have all of the substantive, all of the topical information that you would require. And then we'll talk about some of the processes as far as what you have coming up for due dates and deliverables and all of that good stuff. So hopefully that sounds good, because we are going to delve right into the intellectual property survey. So the first thing we look to when we look at intellectual property is we need to think what this is all about. Overwhelmingly, the businesses this month are intellectual property driven. Our entertainment industry lives and breathes in intellectual property. So when we're looking at anything in the entertainment space, we're always looking at different elements that are creating value based on items that are coming out of your imagination. So with this overview, we have 4 main categories that will fall into this space. First, we are looking at trademarks. Trademarks are going to relate to branding. So our business, the last one in the chat box here, dealing with branding and marketing, trademarks are really a big heartbeat if your company is really living in that branding space. Secondly, are dealing with patents. Patents are dealing with science and technology. I know one of the news bites that I was able to catch earlier today was talking about patent law in light of what's going on in the world right now and how we might safeguard or change regulations dealing with our science and technology to make sure that everybody is getting as safe as they can, as efficiently and cost effectively as possible. So we're looking at patent law to see how to further that cause. Next thing we look to are copyrights. Copyrights look at the arts and all sorts of elements of art and design. And then lastly, we look at trade secrets. And trade secrets are our competitive advantages. These are things that are going to give us an edge compared to someone else. So when it comes to intellectual property, trademarks, patents, copyrights, trade secrets, these are really the heartbeat of our entertainment industry. And when you look at any of our creative businesses, this is really the air that we breathe to a large extent, just making sure that everything is safeguarded and that we're really adopting best practices. So the first thing we look to are trademarks. And with trademarks, we're looking specifically at our source identifiers. We're looking at our branding elements. So if you could pop into the chat box and put one of your favorite brands. It can be anything. One of your favorite brands. So go ahead and give a shout out to one of your favorite brands. We'll see if we can get.
I really like Audio-Technica.
I think we might have lost you there. If you could just type in the chat box so we can look at the brands here. So far we have about 4 brands, the chat box. Any other brands that anyone wants to favor here? Are there any brands that you are not familiar with? Any brands new to you in the chat box? Everyone's familiar with all the brands listed?
Yeah, I'm familiar with those, but I'm sure there's millions of brands I'm not aware of.
Absolutely. So we have a note. Tyler, your brands are new. So one of the important aspects to consider when it comes to source identifiers, and I'm going to go ahead and use the first brand that was listed. So the first brand listed in our chat box was the Disney brand. So since I see at least half of those online live should hopefully be near their keyboard, what do you think of when you think of the Disney brand? What pops in your head? What's that word association? Okay, princesses, family, children's films, childhood, Aladdin, singing. These are all really good, happy things. I just watched a summary of a COVID task force meeting, and the theme parks all are staying arm's length at reopening. So this is like the feel good that I needed right now. And I feel like the Disney brand is very happy somewhere since they are trying to figure out their safe reopening structure. So we have lots of things that aren't theme parks and rides and, you know, pretzels and pineapple ice cream and churros and things like that. We have a lot of elements related to childhood, to content, to characters, singing, family, things like that. So when we think of source identifiers, we're thinking of that affiliation. You hear or see a brand, you affiliate back to whatever that item is. Welcome to source identifiers. So with these other brands that didn't have questions, one of the other brands, just top of mind that I still remember, the brand Tesla was mentioned. What does Tesla cause to pop into your head? What do you think about when you think of the brand Tesla? Cars, sustainable.
Innovation.
Innovation. These are really good word affiliations. Usually it's cars, 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 cars. So this is definitely a good thing. Thinking about other affiliations. We're looking at that source identification. One of the easiest ways to think about trademarks, those of you who take road trips, it's those visual icons on the sign when you're driving. So we aren't necessarily going to put a sign at an exit that's going to have every single brand listed in words like a directory. We're just going to pop up there 6 logos, visual manifestations of the brand, and let you look over, see a logo you like, and decide to turn your turn signal on. Welcome to source identifiers. We're not even necessarily putting the brand name. We aren't putting a menu item. We aren't putting pictures of food. We aren't putting anything else. We're just going to put the picture of the brand up there, the logo, and hope for the best because of the source identifier. Probably one of our strongest source identifiers because of the way they redesigned their trademark about a decade ago is Starbucks. Starbucks Coffee decided to eliminate the ring around their logo that said Starbucks Coffee, and they just went with that mermaid image because that brand was so very strong. So we want to look at the qualities of the products and of the services that are offered. Your brand is going to be synonymous with whatever you deliver and vice versa. So it's important that you deliver good quality, good service. Right now, as a snapshot in history, we're in a really interesting spot with a lot of brands. If any of you have a favorite brand that you are waiting to have come back live, if you favor a brand or a company that right now is closed. I know prior classes, I had some students who were really hoping that different venues would reopen. They could see different shows, things like that. The local government is looking really closely to see how to best reopen because we're very concerned about public safety. We want to make sure that individuals are protected. No worries, no worries. So we want to make sure individuals are protected. So safety first. No company wants to be affiliated with something that is going to cause risk or danger. So this is a really big focus area right now for safety, for services. Keep in mind, if any of you have had a bad experience with a brand, I know for me personally, probably if I have to think of bad experience with a brand, always top of mind, and it was from 25 years ago, maybe a little more. I got wretched food poisoning. Awful, 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 awful food poisoning. You could give me $1 million. You could give me $1 billion. I still would not eat from that restaurant. I will not name that restaurant because I don't want to throw shade on the brand. For me, that restaurant is done. Not at all. Does not exist to me. I want nothing to do with it. So with that being said, if somebody wants to go to a restaurant and they're like, hey, here are 5 restaurants, I will just vehemently say, no, I don't even want to think about the story. I'm right now feeling like that emoji where the entire head is green, kind of like, but with that being said, it killed the brand for me. When I called the restaurant, they explained what happened. They explained why I was sick. They knew why I was sick. It was something wrong with their staffing and their training, and like everything that could go wrong did go wrong. And they were 1,000 times apologetic. Don't care. Don't care. Don't care. Sorry. 72 hours of my life, wretchedly ill, ended up in the hospital. It was awful. Want nothing to do with the brand. You don't want to have that story with your brand, particularly if somebody has a bad experience and they nowadays put your brand just blasted everywhere for negative aspects. That's not okay. So we want to make sure we're looking closely, ensuring good quality of products and services, ensuring consistency of quality in products and services, and that we're really respecting our brand as a whole, and we're putting our best face forward. So we look closely with this with our source identifiers, because your brand becomes iconic is the ultimate hope and goal. Now, with that being said, our trademarks are going to cover a number of different items, and you can see here a roster of main categories. When you're looking at branding elements related to your company, we have a lot of different factors to consider. First and foremost is dealing with your name. So when it comes to your trademark, your name is always front and center. Your name is what people will shout out in a chat box. It's what people will search on the internet. It's what people will look to when they're trying to find your business in a directory somewhere. So name is always top of mind when you're trying to protect your company. Trademarks are not cheap. Federal trademarks cost around $300 per individual category of use. So most companies, unless they're financially stable and have the luxury of having some extra cash, most companies have to pick and choose. They can't go in at the beginning and register multiple types of marks in multiple usage areas. So you got to pick your battles. So when it comes to the name is usually high on the list because it's what you'll say and it's what people will search. Secondly is the logo. And this might be the most important thing to you. It really depends on your brand perspective. Logo is that visual manifestation of your brand. So if you hopped onto our learning platform, onto FSO, to be able to hop on the session tonight, you saw the airplane, the orange logo, the visual manifestation. You see the plane, you see that orange logo, welcome to Full Sail. If you see a different logo, you are going to affiliate it with a different group or organization. So we want to watch this for trademarks for brands. Third thing we look to are slogans. Slogans are going to be our taglines or catchphrases. Slogans are our taglines or catchphrases. So in the case of Nike brand for athletics, their slogan is just do it. McDonald's in the fast food industry has their slogan, I'm loving it. It's that tagline that people will identify with. Fourth thing we look to are mascots. If any of you are sports fans, I know this afternoon I caught just a quick snippet dealing with what fall sports might look like. If I have any NFL fans.
Wait, what are they going to look like? I'm a huge NFL fan.
So there is a proposal, wait for it by the end of the week, because with the reopening, you never know where this is going to land. But if any of you are NFL fans, I grew up right outside of Cleveland. Go Browns. I'm a Browns
Go
fan.
Browns.
No matter what happens, yay, go Browns. So as a Browns fan, I can deal with anything. Oh, Giants. My cubby mate at Full Sail is a big Giants fan. So go Giants as well. But with that being said, the NFL is looking at potentially pitching a schedule where they would have the normal season games. So they're debating, and this is all fully up in the air. The NFL is going to announce later this week an official plan, but they are looking to throw out preseason, understandable, because they're hoping that this thing gets itself under control and can push back training more into the preseason timeline. So give some additional time to be able to let social distancing and let everything that we're doing right now kind of run its course a little bit and allow larger groups to be able to convene. Because when you're looking at an NFL team, you're looking more than 10 people that are all 6 feet apart. So they're hoping, it sounds like preseason will become training season for the team. Individually, everybody can go ahead and train, but to get the team together, that's a little bit different. And then they are looking at maintaining the traditional schedule, but they are looking at taking the stadiums down to, one news story said 20% capacity, and one news story said 30% capacity. So I don't know. I also saw posted on social media by somebody who's kind of tangentially knows-ish, a little bit more gossipy than I would lean on, a higher percentage. So it looks like the stadium would be a quarter full as kind of a split the middle difference ish is the hope and goal. Now, no, everything is subject to change. If any of you have watched the numbers, I know that's where we're all sitting right now. We're all looking at the numbers to see what's going to happen. If I have anybody from Georgia, Georgia is a little bit ahead of us than Florida, but we did have a number of states that have put a lot of things live again slowly. So as long as things don't go wild, it looks like some of our sports are going to try and start figuring things out, integrating fans. There's been some discussion with baseball potentially rolling out, but with a lot of limitations. So it'll be interesting to see because a lot of sports fans are really hungry in this space. In addition to that, we have a lot of athletes that are trying to figure out what's going to happen, which mascots are always top of mind. A good bit of the time when you think of sports, that's usually a pretty public affiliation between mascots and such. So we are looking on the collegiate side. The collegiate and the high school, the school sports are really the ones that we're all kind of holding our breath, waiting to see what this looks like next. But mascots are very, very well known. So our mascots are really those iconic 3D elements that we'll use to help promote. So regardless of what team you may be a fan of, there is likely a mascot or possibly a mascot. My hometown actually has a bank that has a mascot. When I came home to visit, I'm from Northern Ohio, needless to say, when I came home to visit a few years ago, I walked into the local bank. At some point, I don't know, because I haven't lived there for years and it's a regional bank, but they have a mascot that's a mouse called Cheddar. So Cheddar the mouse meets with kids, I don't know, once a month, something like that, and hands out these little prizes, and Cheddar the mouse teaches you how to save your money. It's this cute little mouse character. So they have their own little mascot. He'll stand outside of the bank and wave if it's nice weather and kind of recruit kids in to make sure that they're thinking about saving. He'll go to schools, et cetera, et cetera. He's the mascot for their kids program. A little bit different. You additionally will have characters that will serve as trademark protected brands. Here in Central Florida, we are the ultimate magnet. We are the most obvious selection to look for characters in this space. If any of you are fans of Star Wars, it is the 4th of May. May the 4th be with you. Anybody have a favorite Star Wars character? It's like the easy.
Jar Jar Binks.
The Child or Darth Treya.
Okay. I'm hearing all these great characters.
Darth Vader.
Darth Vader is getting a shout out. Child's getting a shout out.
I've never watched any Star Wars. The only thing I watched was Mandalorian. So maybe Baby Yoda.
There you go. So fun fact, I never actually saw any of the Star Wars franchise until I was working in the legal department of Planet Hollywood International back when they had over 200 locations. And the day I got hired, I was told to leave so that way I could go ahead and attend the major grand opening event that they were hosting here in Central Florida for episode 1. And I explained to my boss I had never seen Star Wars in my life. And he looked mortified and started power counting on his fingers to figure out if I would have enough time to watch the 3 prior movies before I showed up that night for the midnight grand opening event that was being hosted at the Planet Hollywood location / at what was then called Downtown Disney's movie theater. Needless to say, I jokingly, and until the last time I spoke with him, I told him, I said, I may watch them in order. That was about as close as I could get. So I'm a big fan of the Ewoks. I have not seen the whole Ewok movie, but I'm a big fan of the Ewoks. They're like teddy bears seeking revenge from what I can tell.
Don't watch the Ewok Christmas movie. Just trust me, do not want to watch it. I'm a huge Star Wars fan, and it's a huge letdown.
Nonsense. It's the best Star Wars movie made.
Oh, yes. It's also one of the critically worst Star Wars movies made. Actually, it's
They're right
made it
next
to
to
the top
The Last
100
Jedi.
worst. Well, that has more praise than that movie. I'd rather watch Last Jedi.
I'm on such a roller coaster of emotion. I also am very blessed to sit next to somebody who's a huge Star Wars fan as well. So I get all of my Star Wars trivia and information and street cred from the course director who sits right next to me on campus typically. So any Star Wars trivia I can run by really quickly. When you look at our major franchises, and Disney got a shout out earlier, when we look at Disney as a franchise and you start looking at trademarks, thousands of trademarks fall under their umbrella. Of course, you have some of the big iconic Disney-based characters. Aladdin got a shout out earlier. We got a general shout out for princesses. You additionally now have the Star Wars characters getting shout outs. We could always delve into characters within the Marvel universe. There are so many pieces of intellectual property, so many characters that live in that space, thousands and thousands. So when we're looking at trademarks, we're looking at maintaining these characters, putting them into some form of commercial distribution, making sure people can buy items in the different classes or categories where they're being sold. And you see different franchises being re-energized because one important thing to know with trademarks is we have to have commercial sales every decade. So when we're looking at energizing those sales, how do we go through and do that? Maybe it's a ride, maybe it's a movie, maybe it's streaming content, maybe it's some sort of a reboot. It could be a bunch of different things, but we want to make sure that our characters are getting sales in whatever categories of goods we want to sell every 10 years, because that's how you maintain the trademark. So know that that's a really important thing. Also know that some companies do this in really cool, unique ways. So as an example, when it comes to Disney's iconic mouse character, when it comes to Mickey Mouse, you see the Disney Corporation being really creative. And one of the things that has been created is a clock face. So they sell a clock, and that clock face has an evolution of that character. It's a really effective way to be able to protect the Mickey Mouse character, 12 different incarnations of that character. When it comes to watches, timepieces, anything that would fit in that functional home decor category for a decade. So there are some tips and tricks here. It's something important to know. So branding, I saw branding as one of the big focus areas for one of our businesses. So branding is a big focus area. Merchandise is definitely just send me a message, drop me a note. I'd be more than happy to go through and give some more details as you maneuver in this space. In addition, with trademarks, we also look at colors. Colors can be distinctive and iconic. Here we're thinking of colors like the unique robin's egg blue shade that's used by Tiffany's Jewelry, the unique red shade that's used by Coca-Cola. We have a number of different unique colorways that are honored by different companies. Know that you are not getting the entire spectrum of the shade. You are getting a very specific version of that color in affiliation with a very specific use. So when you look at the Coca-Cola Classic can, that shade of red is affiliated specifically with that beverage. You may have a very similar, the same shade of red on the bottom of a pair of women's high heel designer shoes. Shoes are not soda. They can coexist. So you can have red soda cans and red soled shoes, and they can both live in this universe because they are slightly different usages and slightly different shades. The next thing we look to are scents. With scents, we're looking at everything from room fragrance to perfume, colognes, scratchy sniff stickers, smelly markers, a whole bunch of things will fall under scent. Numbers are what they say they are. So numbers, we're looking at things like the band 311, where it is literally the numerals 311. So those numbers are identifier of that source, of that group. In addition, we have 2 specialty trademarks. One of them are collective marks. Collective marks work with a collection or a group of individuals. Collective marks apply to things like charity organizations or professional organizations or other groups. So collective marks like Girl Scouts, Boy Scouts, Girls Club, NISA, Mensa, anything like that, any of our national organizations, national certification or national qualifications, I should say. So for collective marks, we're looking at those groups. If any of you are part of a professional organization, as an example, this is a collective group. If any of you have ever participated in Toastmasters, or you're part of an honor society or a club as part of campus, or something that's an interest in your local community, welcome to the collective trademark. So we look to this. So if you have, as an example, ASCAP, you're a member of that group. When we look more deeply at this, we then may consider trademarks being put on you as a stamp of approval through a certification mark. With a certification mark, here we have somebody stamping and endorsing you specifically. With certification marks, if I have anybody who's certified, usually I'll have students sometimes with OSHA or other safety organizations, sometimes with software companies or other training groups. If any of you have been working with any of the lynda.com or the LinkedIn learning platforms where you've had some sort of certificate or credential that's popped up, that would potentially fall under certification trademark. So you have a brand that's coming along and saying this person is qualified, they are knowledgeable, we put a stamp on them. You see certification from time to time with organizations like Good Housekeeping, like Consumer Reports, things of that, where you're endorsing products. They're saying that these products are really good, that they're really safe, that they're well qualified. Certification marks put that endorsement in place. If any of you have seen the news recently, needless to say, a lot of the recent news is going to focus on what's going on with current events, which means it's going to focus on this pandemic thing. Today in the news, 2 big stories with certifications. Number 1, certifications related to food safety. If any of you have seen any of the news stories with food safety, particularly dealing with protein, meat processing plants, dealing with certification for food safety, food processing, best practices, things like that. We've seen some discussion dealing with certifications and endorsements in that space. We also have seen some discussion big time today. I've only watched maybe 45 minutes of news, but big time discussions dealing with certification and endorsement of tests. Private labs being able to certify or endorse their own tests. Now there are additional levels of checking coming into play, of assessment, to make sure that third parties are going through and certifying and endorsing tests. So a lab can't create a test and say our test is great and perfect. A third party needs to go through and review it and say all of these tests meet the same criteria, all of these tests are good, just to make sure we're all running under the same rules. So you now have an organization that will be the one with the stamp saying these tests are worthy, these tests need some additional work or help. So the certification, that endorsement comes into play. We additionally, we additionally, hopefully, we'll look at the next slide. There we go. Looking at trademark protection, we have to look to see with our trademark protection how you are registering. So we want to see, can we register your trademark at the state level or the federal level? Know that you can register at the state level fairly efficiently and affordably. It is more expensive to register at the federal level, but the state level protects you within the boundaries of your state. So a Florida state mark only protects you within the boundaries of our state. Federal mark will protect you across all 50 of the states, any of our districts or territories, as well as having some reciprocity, some understanding with about 100 other jurisdictions. Always helpful. We also need to remember that trademarks will give us a maximum of 10 years of protection, but they are renewable, which is really important. This is the only time I'm going to mention the word renewable tonight, because trademarks are the only type of intellectual property that we can renew. And the logic behind this is we don't want amazingly great brands that have existed for years and years and years, like your favorite pro football team or your favorite Star Wars character, to have to rebrand every 10 years. So those iconic brands from a century ago can still stay iconic as long as they have sales and commerce. They can renew those brands. Now, with that being said, you can use the superscript or subscript of TM or SM for trademark or service mark at any time, whether you're registered at the state level, at the federal level, wherever you're registered, you can use that TM or SM wherever you would see fit or appropriate. However, to be able to go through and use the ARNA circle, which you probably have seen with some brands, to use the ARNA circle, you must be federally registered and federally approved. So you have to go through the process of registering with the U.S. Patent and Trademark Office. You have to await the USPTO going through and reviewing your brand and officially providing you an approval for your brand, as well as rules and regulations that would come into play as far as how you would roll out the ARNA circle. Do not use the ARNA circle without federal approval. It is deemed to be fraud. Horribly bad idea, just as a heads up. Next thing we look to are patents. And with our patents, here we are looking at 3 different types of patents that are going to be key focus areas. For our patents, the first type of patent is a utility patent. Utility patents are items that have a utilitarian or functional purpose. Man alive, when it comes to medicine, we have never seen more discussion of utility patents in the universe. So much discussion when it comes to our current situation. So much advancement, as a heads up. Lots of technology has advanced. If any of you have seen news stories, and you're welcome, throw a Y for yes or an N for no in the chat box. If you've seen news stories about companies that are making new devices, new safety gear, new protective equipment, they're making different items to be able to enter into the market, to be able to help people with our current set of circumstances. I know here locally, we have a handful of companies that are printing, 3D printing face shields. We have a few different groups in Central Florida who are creating ventilators that can be made within a matter of a half a day, and they can be made with some things that aren't as outrageously expensive as traditional machines. We see a lot of technology being discussed. They're functional, they're utilitarian, they can be protected by a patent, they are good for 2 decades. Second type of patent are design patents. Design patents only last 15 years. They protect elements that just look cool. Design patents, non-functional design elements of an item. So design patents are going to be things like hood ornaments, packaging for products, other items that don't have a functional purpose but do have a look to them. And the design patent element protects that look. And then lastly are plant patents. And with our plant patents, these will apply to agriculture and botany items. Plant patents are good for 20 years as well. And they will safeguard the unique design of that lab-created plant. If any of you are super into botany or agriculture, you can hang out at the end. I'm happy to geek out. But I can give you an example. We had a case that came from India. It's been about a year ago now, where somebody was growing the potatoes that were patent protected by Frito-Lay company. If I have anybody on this session who is a potato chip connoisseur, There is a specific patent protected potato that is used to make Lay's classic potato chips. And this farmer was growing them without proper license to be able to have those potatoes and seeds. Thus, you have an infringement case. This is why I love my job, because I get to research things like infringing potato chip farming cases, and I can watch the Supreme Court argue a trademark case from the comfort of my own home from earlier today. So good. But with our plant patents, they are good for 20 years. Utility and plant get more protection than design because there is more R&D that goes into this. Way more research and development to be able to create a functional prototype and to be able to showcase a solely lab created plant versus design, which won't have that same level of complexity when it comes to the blueprints and proof of functionality and uniqueness of the design itself. It's a little bit more of a streamlined process, which is why you have more of streamlined timeline. Now, our utility patents are the largest category where patents will be registered. Utility patents are the ones that you will see patent pending documentation on and identification on products. And for a utility patent to exist, it requires three things. Number one, it must be something that is new. It has to be novel. It has to be unique. It must be something that's new. Novelty is king when it comes to utility patent. This cannot be something that exists somewhere else in the world, in your industry. This cannot be something that's been published, that there's an existing prototype, that it was discussed. Our patent office takes a long time reviewing applications. Trademarks at the state level typically take about 60 to 90 days, depending. Our COVID timeline and hurricanes, sometimes we'll throw that timeline off. It's usually faster, but I'll say 60 to 90 just to be safe. When it comes to federal trademarks, those federal trademarks usually take 18 months, potentially as long as 3 years to process. Granted, some will go faster, but 18 months is a pretty good middle of the road. Utility patents, hands down 3 years, at least. Utility patents take a really long time to process because our patent office is checking every corner of the universe to make sure nobody has talked about this, has written about it, has created a prototype, has published a video. They want to make sure it exists nowhere else in the universe, in your industry. Second thing, we want to make sure that this thing is actually useful. It's functional. It has a purpose. It does what it says it should do according to your application. And it's important to know what your application says it does. Doesn't have to be what it goes to market to do. So if it's kind of an off usage, as long as there's a functional purpose for the original application, you're good. If it's being misused in a different way and it still works, as long as you had a use originally that is possible, you are not typically losing on use. Use, you probably have some latitude from our prior cases. You see some leeway in this space. So we need some sort of functional, utilitarian, has the word utility right in it, purpose. So it has to be useful. And then last thing, it has to be non-obvious. It needs to be something that even outside of your industry is new and unique. So we can't take something that already exists and just plug it into your industry and take credit like you created a new thing. That does not work. So when we're looking at the new, the useful, and the non-obviousness, we need to look really closely to make sure that it's new within your market and it's non-obvious in competing markets. It's part of the reason it takes so long. So if you create an item like a lens for a camera, on the new part, that first category, that novelty element, we're gonna look at all the other camera lenses you can possibly think about. Think of every camera lens possible. On the non-obviousness, we're going to look at lenses that are utilized in the space program. We're going to look at lenses that are utilized in kids' kaleidoscopes. We're going to look at lenses that are used on motorcycle headlights. We're going to look at lenses in all sorts of other categories just to make sure you're not snagging it off one product and slapping it on a camera. That's where the non-obviousness comes in, that it is something that is truly a unique creation, which is why it takes a while to get that patent application to go through. So just a heads up there. With our patent protection, it's also important to note that you are getting an exclusive right to manufacture, use, and sell this item. So as the patent holder, you get this exclusive manufacturing, use, and sale of an item, meaning you can make as much or as little as you would choose. So you can push scarcity in the market, or you can flood the market. It's up to you. You only have 20 years total if it's useful or if it's a plant. So maybe you want to flood the market, sell as much as you can during those 20 years. Or maybe you want to have scarcity to have better control of the market during the time that you have the patent. It's up to you. You can also control who has the ability to use the item and who has the ability to distribute the item. Every company is going to treat this differently. And you've seen a lot of news stories right now, if you follow the news, dealing with the pandemic when it comes to pharmaceutical manufacturers. Some have explained that if they find a cure, if they find a vaccine, if they find something, that they will drop it into the market and they will make every kindergarten teacher proud during Give Teacher Thanks Week, Teacher Appreciation Week. They will make every kindergarten teacher proud because they will share and play well with others. We've had a few brands that have said, if we're the one who finds it, we will share it with everybody. We will mass manufacture. We will put it at price points that the market can bear. We will activate it in distribution channels as quickly as possible. We are solution driven. You have had other companies that have unapologetically explained so much goes into research and development, so much goes into testing, that if they're the one who gets it, they will be the one who owns it. They will be the one who will source it out. They want to maintain integrity. They want to maintain ownership. They want to maintain control. They will determine an appropriate price point based on current market standards, et cetera, et cetera. Two different perspectives. One's not necessarily worse than the other per se. It's just two different perspectives. So it's up to the business as far as how they want to handle manufacture, use, or sale. If they want to go through broadly distributed at an affordable price, if they want to go through and look in this example at the humanitarian side versus the economic impact to their business, et cetera, welcome to patent protection. You control that pipeline. You have an exclusive right on whatever it is you create. In addition to this, you have federal protection, which is part of the reason why, if you've seen the news at all, lots of intellectual property protections being discussed. There's been some talk, particularly from governments like nation governments like the US, like a few European countries, a few Asian countries, have had their leaders speak out about the fact that if they are first to find a solution, their country will. And then they're talking about how things will work. It is a federal patent protection, so it does apply and protect domestically here in the US as an example. So it is country specific. And patents are not renewable. We want you to continue to improve and innovate over time. So at the end of the 15 years for design, at the end of the 20 years for utility and for plant, we want you to innovate. Now, when it comes to utility right now in the tech space, if any of you purchased a smartphone and you've had it for more than 12 months, that thing is like borderline vintage. Most of our technology is improving at breakneck pace. So the renewability in certain categories, there's not a whole lot of movement in that space. Other categories where we need to kind of nudge folks, we have to make sure that they know your patent will fall out of patent protection. It will fall into public domain. Anybody who would want to make it to sell it, to use it, can do so as kind of a do-it-yourself. Two key things to note, and we'll delve more for my campus cohort, we'll delve more into this end of this week, beginning of next, but it's important to note that when it comes to patent protection not being renewable, you see two options for companies. Number one is to innovate. Find a bigger, faster, better, sleeker, more efficient, whatever, update and upgrade. The other option, let the patent expire and bank on your trademark. That's the other option, bank on your trademark. I have horrible allergies. So when we first started shelter in place, I was one of those people who would sneeze and everybody on my video session would kind of gasp, and I'm like, it's just allergies. And you're on a video session, but it's just allergies. It's now over the counter medication, no prescription needed. It's a brand that's existed for over 20 years. It works well for my allergies. My doctor has been very transparent. Just go to the pharmacist and ask for that brand product because that's the formula that works for you. If they make a new brand or a new product, which rumor has it they've either made one or in the process, I still want like the 1.0 version of it because that's what works. I don't want to mess around. So if you don't renew, at least keep that trademark alive. And you're going to see these intellectual property forms sometimes will dovetail together really efficiently. So if that's the case, we want to make sure if the patent isn't renewing, we're not upgrading or refining, how does the brand step in? How do we improve and make things better? We then move on to copyright. So we've looked at trademarks, which are source identifiers. We've looked at patents dealing with technology and science. Now we move to the world of copyright. And with copyright, here we're protecting the arts. The majority of your companies are living and breathing in this art space. 100% of the companies I've met so far, art is somewhere in the DNA of your business. So with that being said, the arts are going to cover main categories: sound recordings, textual works, performing artworks, visual artworks, as well as serial works. Audio content, written stuff, things that are live, performed, or broadcast in a variety of ways, 2D or 3D artwork, and things that come out in a series or sequence. These are going to be our main categories of art. There are so many subsets that are going to come into play. So some quick examples, just high-level stuff to consider. Books, ads, and programming code, the written aspects of your code, of your About Me page, of your non-fictional works will be literary works. Those are textual or written works. We additionally will have scripts, manuscripts, and video works protected under performing arts because scripts, manuscripts, and other fictional works are anticipated to be performed in some way. Choreography will fall under performance as well. You'll see actually dance routines, choreographers will enforce their rights. 2D and 3D artwork will fall under visual arts. This will include everything from jewelry, painting, sculptures, drawings, photography, all sorts of different elements, carvings on massive ships, etc. There are all sorts of different elements that'll fall under visual art, including blueprints. Blueprints are deemed to be visual art, as will be technical drawings, if any of you would be doing live show production, anything like that, lighting design, things of that nature. In addition to that, within our audio side of things, not only do you have the sound recording aspects, looking at composition melodies, you have potentially under sound recording the lyrics. If the writer and the performer are the same person, lyrics may fall under literary works if it's somebody different creating the lyrics. And then of course we want to safeguard performance, performance of musical works, performance of theatrical works. It's very broadly drafted. For our copyright registration, you must register with copyright.gov. You must register with copyright.gov. Must. U.S. Supreme Court says you must register with copyright.gov. So you must register with the US Copyright Office to be able to enforce your rights to any content you would protect. Copyrights are the most affordable form of intellectual property. Trademarks are about $300. They're good for a decade. So it's about rough math. I don't teach finance. Let's embrace that. Rough math, it's about $30 a year. You have to pay it as a lump sum, but it's about $30 a year. Patents are going to be anywhere from $400 to $800+ just for the application, not including the legal support, the blueprints, etc. Most of our patents we're looking at $10,000 to $25,000 to register with all of the experts, all of the drawings, all of the supporting details. Copyrights you can register for less than $100, and they're good for your life plus 7 decades. Copyright registrations you can register for $35-ish, $55-ish, $95-ish. It depends on how you're registering them. There are a few different factors for price points. I am going to lean into my lawyer geekiness for a hot second here. And with all the seriousness in the world, for my content creators, and I know I have content creators currently on this live session and hopefully in the archive as well. For my content creators, nothing makes a better graduation gift, birthday gift, anniversary gift, any other holiday you may tend to celebrate in the whole year. Nothing makes a better gift. Copyright is a potential revenue stream for your life plus 7 decades. It will last longer than a gaming console, than a subscription to a streaming service or a magazine or something like that. It will last your life plus 7 decades. It is a pretty cool gift. I will now step down off of my lawyer geek out soapbox and carry on. So your copyright registration is going to do a couple of things. Number one, first and foremost, it gives federal notice and identification to anyone who would want to use the works. We know who owns it, we know who monetizes it, we know who to contact if we want permission to use it. All of the information is there. In addition to that, your copyright registration gets you access to our federal court system to enforce your federal copyright. It gives you the ability to request statutory damages, which are a mathematical equation based on the number of infringements that occurred. It's an easy multiplication. And then lastly are attorney's fees. With a registered copyright, you can request attorney's fees, which this is crucial. Copyright litigation is expensive. You want to spend the time and spend the cash. For our copyright protections, we additionally look at 5 key rights. Number 1 is the right of reproduction. This is the ability to make copies of content. You may want to have just one of the thing that you're creating, and just that one thing is the only copy of that thing that you created. You may want a billion copies of the thing that you created everywhere in the universe. It is up to you as far as how you control the reproduction of the work. How many copies do you want in existence? Second thing is adaptation. Adaptation is making a derivative work. So with an adaptation, this is where, as an example, we might take a comic book and turn it into a kids' TV series. We might take that and turn it into a live action TV series. That might become the basis of a film, that might become the basis of a video game. With adaptation, we're changing or altering the story. This can be a reboot. If I have anybody who's a fan of a franchise that's gone through a reboot, sometimes it's good. Sometimes you just kind of wonder what happened. But with that, welcome to adaptation. So if we're taking content and we're changing it, we're moving it to the modern day, we're changing the characters, we're putting the story through a different lens, we're taking a short story and turning it into a feature-length film, we're taking a video game and turning it into a movie, whatever it is, welcome to adaptation. We're maneuvering this intellectual property into other spaces. We're making a remix of a song, or we're going through and sampling a beat and integrating it into content. We may be taking intellectual property and integrating it into our set piece or art design or something of that nature. We need to have those rights for those usages to be able to get those clearances and permissions. In addition, we have the right to publication. This is the right to be able to distribute content with the intent to promote or monetize. Publication looks at the distribution, not the monetization. So if you are distributing infringing goods for free, you are still infringing, which is an important thing to note. So publication is that distribution with some sort of intent to have some sort of exposure, some sort of financial gain, etc. Definitely there are some intellectual property projects. I have a film being listed. There are some IP projects that require so many clearances and permissions. So keep in mind, I've worked in the industry for about 20 years. We actually have some grads who deal with permissions and marketing in particular. So when they're dealing with different projects, every now and then I'm fortunate enough to have a few grads who will reach out and say, you know, man alive, this project coming up has X number of different things that need cleared. Or they'll reach back out and say, oh my gosh, you have to watch this project and just pay attention, because living and breathing in this space, I notice a lot more and kind of have this odometer tally in my head when I see tons of trademarks that we have to clear, tons of copyrights that we would need to get permissions for, et cetera, et cetera. We additionally want to look at the ability to perform. When it comes to performance, everybody is going to have their own threshold if it's okay or not. So with performance, this is a big hurdle that we have run into recently. I know I had a friend of mine reach out to me because their child was graduating from a theatrical arts program, and their child originally, when they knew they were getting to graduate, they had a professor who said, hey, the last thing we do is we all sit in a circle and for fun, we perform our favorite song from our favorite musical. Just in the theater one day at the school. We just all sit in a circle and infringe and try not to have the place burn down. Everybody's remote now. So the prof came up with this secondary great idea of everybody record your own infringing content on your own and upload it onto all of your social media platforms. How did that work out? Anybody have any ideas? Let's all go to our corners, make lots of infringing content, and then upload it on social media platforms.
They were probably swiftly taken down, I
Yeah,
assume.
super efficiently taken down, which is why the parent of the performer called me all kinds of fiery mad. Like, you know, people who work at least 2 of these platforms, you need to reach out and get this stuff put back up. And I'm like, what's this? So your child is infringing and publishing this. Why is your child doing that? Well, she's doing it for free to celebrate her graduation. Okay, well, what does your child want to do next? Well, she wants to work for the show that she's doing the performance on. Okay, so it's not free. It's your kid's infringing demo reel. No, you are still going to have issues with that. So you've got to be really cautious when it comes to this. The projects will license it out. It's why if we could all just grab big shows, if any of you are fans of musical theater, if you watch the Tony Awards, if you were in that performance space, or if you're just a fan of musicals, if you could just grab any Player musical and stick it into your program, it would be the Wild West. Instead, you have different venues fighting, just like you see with any tour or any program that would go through. You have to fight to get access to that show. If anybody could perform anything, anywhere, you lose that monetization. You lose that exclusivity. So you gotta have that license. The last thing we look to is right of display. Display has been one that has popped up with everybody going through in this bold new space of online. This has been the place that has caused a lot of folks heartache, because One of the things we quickly learned is we have to look at the environment that is surrounding us. So we've had a number of filings based on people's backgrounds when it comes to the video content that is surrounding them because of display. As a matter of fact, an artist that I know here in Central Florida who also does a lot of meetings on conferencing platforms had found a background design that you can customize and you can actually put your own artwork in a frame. You take a picture of the artwork and then you can drop and drag it into this little template thingy and it makes it look like your artwork is framed behind you. So the artist is cool. The artist thinks this is a great idea. The artist puts it somewhere to go through and access it. And then the artist reaches out freaking out because they put it somewhere on the internet to be able to use it on whatever the platform is that they used for conferencing. And it is now a template background that you can download and use. And the artist is super upset because now this painting is being displayed across anybody who downloads this template for free. The artist is climbing the walls right now regarding this. Guess what? You uploaded it, you surrendered your right to display. You've got to go through, you've got to look at those terms of use. Didn't pay attention, didn't watch the details of the licensing agreement of utilizing the template, dropping and dragging it into that format. You got to watch for that. Now, if I buy a piece of artwork, I'm really sensitive to this. If I buy a piece of artwork, I do ask, can it be in the background? Can it be photographed? Can it be videotaped? If it's in my office space, is it something that's on the wall that I stare at and personally enjoy, or is it something that's on the wall that gets broadcast if I'm doing something where I can't have a backdrop behind me? So basically, do you live behind my green screen or do you live in front of my green screen is kind of the question that I have to ask with display. More and more asking that question in light of changes. With trade secrets, this is our fourth and final category: trademarks for our brands, patents for our technology, copyrights for our arts, and trade secrets for our competitive advantages. So with trade secrets, we're looking at any sort of process, method, technique that you would utilize that gives you a competitive advantage. It is soon to be, maybe for some, soon to be dinner time. Those of you who ate beforehand, well played, planning ahead. For many of us, we'll probably pop off and maybe grab a bite to eat. You have lots of restaurants right now. Oh, you got a lot of restaurants that are hoping you're a huge fan of their secret recipe, AKA formula, and you are willing to go out and order, carry out, or dine in. 6 feet apart on the patio, 25% indoors, whatever that might look like. For trade secrets, you might also have internally within your company some sort of method, technique, some sort of process that you utilize. Maybe it's how you do your marketing outreach. Maybe it's how you get content through your team to be able to create content. Every company is going to have their own different tip or trick. Working with a lot of businesses, I've seen some really innovative, really cool, kind of quirky things. And sometimes there'll be a business owner that just shrugs their shoulders and they're like, we've always done it that way. Well, your outcome is amazing. Well, we've always had this process and it seems to work. Congratulations, it's a beautiful trade secret. Please don't pull the curtain back because it's going to give you a mad crazy competitive advantage. So lean into that because you're printing money here. For a trade secret to exist, it has to be something, number one, that derives financial value as a secret. It has to be worth cash based on it being a secret. It's printing money for you in the fact that it's not well known. Number two, there is a proper way to learn about it. It is ascertainable by proper means, which is lawyer speak for there's a right way to learn it. So starting at a brand new company, you aren't necessarily privy to trade secret information during your first day of training. Usually as you climb up the ranks, you figure out what's behind the secret door or you learn something about some other competitive advantage. Is there a thing that derives financial benefit that has a proper way to learn it? And if so, is it subject to reasonable security precautions? Do we password code it? Do we limit access to it? Do we make sure that we are taking steps so that people who know different elements aren't sitting together bored at a bar at a convention like, hey, what do you know about the trade secret? And each of them knows one half of that trade secret. You know, what steps do we take? One of our big donut companies, if I have anybody who's a big donut fan, one of our big
I
donut
love donuts.
there we go. One of our big donut companies, if any of you know the significance of when the hot light is on, one of our big donut companies a number of years ago went through and was talking about the trade secret for their original glazed donut recipe. And one of the donut competitors, one of the other brands, was relocating their secret recipe for their famed cake donut from one part of the US to another part of the US. And they had a private jet with a guy in a dark suit with a metal briefcase handcuffed to his wrist doing a photo op of them relocating their secret recipe. You had the competitor go through and issue a press statement saying, y'all are cute, basically. It was very formal, but the net, if any of you are from the South, it was bless their heart. They went through and pushed back and said, if you were to ever find a piece of the recipe, the ingredients would have nothing to do with the directions. And oh, by the way, they're divided into multiple locations spread across the world. You basically have to go and find, you know, the second queen's desk kind of deal to be able to figure out any little nugget of this secret recipe, because they want to make sure it's very difficult, very protected, and that there is a very limited way to learn it, because they do get a lot of cash based on that trade secret. So we want to look at those trade secret elements. Now, it's important to note, number one, first and foremost, reverse engineering is completely legitimate, which is the biggest fear for most companies. Reverse engineering means that you figure it out 100% on your own. So if after the session is over, you're trying to figure out what you want for dinner and you search online. I had a friend do this just this weekend. Buddy of mine desperately wanted something from a restaurant, lives in an area, restaurant, nowhere near where he lives. And he's like, man alive, I just really want this one thing from this restaurant, but I'm nowhere near one of these restaurants. Go onto a search engine, type in the name of the restaurant, type in the name of the dish, poof, 5 websites pop up. Make this recipe at home. And it gives the recipe for somebody who went into their kitchen, played around, and found something that they felt tasted just like the recipe from the restaurant. Now, other places are doing this in a completely different space. And since the Disney company was mentioned straight out of the box as a brand, if any of you on here are fans of the Disney company's park, and especially the food at their parks or their resorts, you might have seen that the Disney Corporation has been actually releasing some of their recipes. I don't know if you've seen it. In case you missed it, you can go online and find them. But you have seen the parks releasing recipes intermittently. I haven't seen any sort of schedule where it's like dessert Thursday or something like that. Maybe it is a thing. If it is, I apologize. I'm a horrible theme park fan in Orlando right now. But a lot of our parks, to keep that energy going, instead of you trying to figure out how to make that pineapple ice cream that some people go wild over, here's the recipe, go make the pineapple ice cream at home. You know, if you really love the pretzel, here's the secret to making the pretzel or whatever it is. They're dispersing some of those items. Here's how to have that experience at home. Take a picture and here's a hashtag, which hopefully for my branding folks, this brings you joy. We can do some different things in this space. If you figure it out on your own, it's reverse engineering. Secret's gone forever. That person has figured it out. So if you figure out, I know A couple months ago, I had a class that got into a heavy discussion about the ease of figuring out the secret sauce on the McDonald's main signature menu sandwich, their Big Mac branded sandwich. I had a few students were hotly debating what that sauce was and how easy or difficult it was. Welcome to reverse engineering, because a couple of the students were like, I've made that before. This is what I used. Welcome to reverse engineering. I straight up asked that cohort, has anybody worked there? Has anybody actually made it as an employee? And they're like, nope, we just figured it out playing in our kitchen. Welcome to reverse engineering. The reason why I ask, has anybody worked there, is because I don't want to be recording some sort of misappropriation issue, because with misappropriation, this is where you have a trade secret that exists, something that gives you a competitive advantage, there's a proper way to learn it, and you take proper steps to protect it. But you have somebody acquire it illegally or via confidential relationship. That's why I chimed in and said, please, nobody be the head chef for McDonald's Corporation who's explaining how to make this sauce at home. Do not misappropriate the trade secret because you learned it via confidential relationship as an employee, as a director, as a manager, whatever that role might be, and then are using it in an unauthorized way. Do not take the information and distribute it in an unauthorized way. This causes us concern. So we have to look really closely in this space. If it's reverse engineered, no worries. If it's misappropriation, if it's an employee or somebody who has broken in, has hacked your network, something like that, misappropriation, totally different setup. Now, to safeguard your trade secrets, there are a couple of best practices, and this is where we're going to kind of wind down the intellectual property side of things here tonight. Your companies overwhelmingly will have trade secrets because, and this is one of the most important concepts from tonight, if any of you are into plants, growing stuff, I know right now one of the biggest markets that has seen a huge boom recently are nurseries and agriculture. People who are trying to grow their own food, people who are trying to do gardening or start planting stuff as a hobby because you're at home and it's a thing to do. It's an activity if you have kids, if nothing else. If any of you remotely have a green thumb, I am not part of that crowd, but I still understand the analogy. Trade secrets are the seeds to every other form of intellectual property. Everything starts as a trade secret. It just depends on whether it then grows into something that you're willing to pay the money to trademark, to patent, to copyright. It can live in that trade secret space. You can keep it out of the sunlight, tucked away from people, and it can just be a trade secret forever until somebody figures it out or somebody steals it. Hopefully neither occur. But most of the time, these trade secrets then will convert. It'll grow to a point you register the copyright. It'll grow to a point you register the trademark. It'll grow to a point you register the patent. So to safeguard the trade secret, which is really where all intellectual property is born from, there are a few best practices. Number one, first and foremost, limit access. Don't allow 7,000 people to be in the mix, or 700, or 70, or 17. Figure out where are those folks that are oxygen for your business. Limit access. If 5 people know, and suddenly you hear this from multiple other people, you know to go back to those 5 people. And if you're one of the 5, it's now you or one of the 4. So limit access is one of the key areas. Physical access, access via any sort of digital format, physical format, whatever it might be. Second, consider non-compete agreements. Put some boundaries around where folks can start and where folks can move. Put some boundaries in place because that's going to be really helpful too. Non-compete is going to limit where you can jump between companies. Non-disclosure agreements are another big area. Non-disclosure agreements, these are contracts that I'm signing off on that I agree not to share trade secrets. And then lastly, are exit agreements. These are contracts that employees will sign when they are parting ways with a company. Exit agreements are a good way to remind and reinforce non-disclosure agreements, non-compete agreements, any other contract elements that you would want to revisit or reinforce. In light of the change in our economy, we saw an influx of focus on these exit agreements, revisiting with employees elements. As an example of non-compete, we saw a lot of companies, if you or someone you know have been impacted by the changes in the economy, we've seen a lot of companies that have, during the exit agreement, said, forget about the non-compete. So if you or someone you know had employment and there was a strict non-compete agreement, we have a lot of companies who are saying, in light of the current market, if you can go work for a big competitor, go hunt down a paycheck. Not every company is doing that, so you've got to look at the terms and conditions. Most companies are still reinforcing their non-disclosure agreements. However, they want to make sure that their trade secrets, upcoming events, upcoming programming, their client list, their customer list, their list of freelancers, pending projects, etc. All those things are still safeguarded. So some things are going to remain sacred here. This is everybody's favorite part of the evening sessions, because this is where we cannonball into best practices and tips for the assignments that you have coming up in the next week or so. So we are going to talk about the IP audit assignment as well as the industry liabilities paper. For my online cohort, these are going to be due on Sunday evening. For my campus cohort, you need to look at Turnitin and FSO to look at those dates. So we'll talk more about it as we move through, but know that you need to check your platform information to see when things are due on FSO. So the first assignment we look to is the IP audit. For the IP audit, you are going to be creating a list of 4 things your company will create. So think about 4 pieces of intellectual property your company will create: trademarks, patents, copyrights, trade secrets. You can have any combination. Any combination. You can have 2 trademarks and 2 copyrights. You can have 3 copyrights and 1 trade secret. You can have 2 trade secrets, a patent, and a copyright. It does not matter to me. Any combination. If you have samples, as an example, a sample logo or a logo that you're currently using, you are welcome, when you talk about the logo, to plunk your logo in there. It's totally up to you. My one request, if you are discussing trade secrets, keep that discussion general. So as an example, if you want to talk about trade secrets and you want to discuss that you want to safeguard your client list, we're good. That's all you have to explain. Don't attach an appendix with your client list. That's not a good practice. It's not a good way to control distribution of things under trade secret. Pick 4 things your company will create. You are going to discuss the thing you're going to create and explain how and why you'll protect it. So as a quick look back at what we talked about tonight, if you want to safeguard your logo, how do you protect your company logo? How do I protect my company logo?
Trademark it.
Absolutely. It's a really good way to save yourself a chunk of points. Trademark is the only thing you're going to do with that logo, and you're going to save yourself a letter grade, and life will be grand. Please do not use any other form of intellectual property when it comes to registering your logo, or else I will be heartbroken on my own side, and you may feel that it is a sad time on your side. So please make sure logos, trademarks, their source identifiers. Talk about how and why you'll protect it. Are you going to safeguard it through the USPTO.gov so you have federal registration? Are you looking at a state-based design? Why are you protecting it? You want to make sure your customers aren't confused. You want to make sure a consumer doesn't, or a competitor doesn't use it. You know, what are you looking for here? What are you protecting? How are you protecting it? And why are you protecting it? I would recommend making a numbered list on this assignment. Item number 1, thing you'll create. What is it? How do you protect it? Why will you protect it? Item number 2 that you'll create. What is it? How and why? Item number 3, what is it? How and why? Item number 4, what is it? How and why? And then item number 5, describe one thing that you'll need a license, clearance, or permission to use, and provide an overview of the process to obtain those rights. Explain that process. 5 numbered paragraphs is the easiest way to approach this assignment. Now, do I have anybody on this session who is like the world's biggest APA fan and cheerleader? Do I have anybody here that APA is your raindrops on
I
roses?
was gonna say, I actually like APA.
Okay, good deal. In that case, just cover your ears for a second. Have you seen the movie Old School with Will Ferrell, where he instructs people to cover their ears?
I love that movie.
When he says earmuffs. Okay, so whoever loves the movie, hopefully that's the person who likes APA as well. Sorry, because the mic jumped really quickly. Just cover your ears for a second, earmuffs. If it brings you joy, I am going to give you some leeway in the world of APA. If this is going to cause you the opposite of joy, wah wah, wah wah, wah wah, wah wah. If this will bring you joy, to approach this assignment, 5 numbered paragraphs, I am not stressed out about you being APA compliant. Technically, APA doesn't like numbered lists. With that being said, everything you need to be successful is either from tonight's session, or you can find it within your textbook by Joy Butler, Your Permission Seeker's Guide. If you are going to include quotes from any sources, they are not required. If you decide to include quotes or additional research, you will need to have title page and references page. If you are only using the content from lecture, from class, or from your textbook, unless you have direct quotes, you do not need a references page or a title page. You may use a numbered list. I highly recommend the numbered list. I have taught advanced entertainment law, fun fact, for all but 3 weeks in the history of advanced entertainment law. Sadly, during the history of advanced entertainment law, I had my appendix leave in a very exciting way, and I also had H1N1. So I have, during the span of the 11 years of teaching this class, I've missed a couple of weeks. It was sprinkled across. I'm still good. But with that being said, the numbered list is the secret sauce to be successful. That way, you know you have those 4 items. You talk about what it is, how and why you'll protect it. In addition, you have that 5th item where you're talking about an item that you would license or need clearance or permission to use from a third party. This needs to be intellectual property based. What trademarks would you use from third parties? What copyrights would you use from third parties? What patented materials would you use from third parties? What trade secrets would you maybe go through and have to negotiate to use from third parties? If you are thinking my company is organically going to create everything itself, we are going to live in a bubble and we will never use anything from anybody else in the universe. I do get this discussion every now and then, this question. Are you really going to create your own devices, build your own unique operating systems, and then build out your own email software and word processing software and accounting software and all of the technology to do the stuff you create on and with? I can guarantee you the answer is no. You're going to license software. You're going to use somebody's patented hardware. So no company is going through like they're on an island with just a simple volleyball, which, oh, by the way, you still have to worry about the trademark on that freaking volleyball. Let's just be honest. So you're gonna need that intellectual property right. Those 5 things are gonna come into play. 4, you create. What is it? How and why do you protect it? 1 thing, you need a license, permission, clearance, whatever it is to use. Your other assignment is your industry liabilities paper. For your industry liabilities paper, you are going to do a deeper dive on 3 potential legal liabilities within your industry. We are looking at 3 things that could get your company potentially sued. Not things that could cause you to lose money, like we decided to put cheese sticks on the menu and nobody orders cheese sticks right now. That's a financial exposure. That's an operations exposure. That's not a lawsuit. People getting burned by them might be a little bit different. People getting food poisoning, that potentially could be a legal risk. But financial loss, I'm not concerned. I've seen a trend recently, just as a heads up, insurance is actually a financial protection from liability. So be really careful. I've seen a trend lately on some papers dealing with the importance of insurance. Insurance in and of itself is actually a financial protection if a lawsuit were to occur. So please be advised of that. When it comes to these liabilities, you can approach this one of 2 ways. 1, you can do a deep dive on 1 liability risk within your business. So since it's top of mind on the news, did anybody see the story of the guy who tried to shelter in place at the theme park here in Orlando?
Yeah, I was just talking about that. That's pretty funny.
Super wild.
Yeah.
Super wild. So if you didn't see this story, we had a gentleman, I think it was a guy from the story that I saw. I just saw a quick headline of it, but we had somebody who had gotten access to one of our theme parks and had actually attempted to shelter in place by trespassing at this theme park. So if my business is a physical location, it's a theme park, and I want to worry about trespass, I might pull the recent case dealing with the person who decided to shelter in place on an island in one of our local theme parks here in Central Florida. I might pull a trespass case from one of our other theme parks in Central Florida where somebody was found dead floating in one of the exhibits. And I might pull another case where somebody was apprehended in the midst of a robbery. They were all trespassing. They were all there after hours, outside of their ticket restrictions. They were all trespass issues. Granted, they all had derivative legal liabilities too, but trespass is kind of the heartbeat. So maybe I want to look at trespass, and I want to look at 3 different situations at 3 different theme parks. Cool. I need to pull actual controversies or actual cases. So I'm not making up a hypothetical. I have to point to this person was on Discovery Island. This person was floating in the tank with the whale. This person was in this art museum found in this room. I need actual, these are real life things that happened. You do need to have sites and sources for this paper, needless to say. The other way you can approach this is you can go more broadly across the board. So maybe I have a physical venue location, and instead of looking just to trespass, maybe I'm looking at other issues as well. So maybe my 3 liabilities, instead of being 3 different trespass cases, maybe I have a case dealing with trespass, I have a case dealing with an employment law issue like discrimination, and maybe I have a case dealing with employee safety. So I have criminal trespass, employee safety, personal injury, as well as discrimination. Maybe those are the categories that I look to. I need 1 example of a case or controversy dealing with each legal liability. This can come from a news source. This can come from a court case. It is up to you, but it does need to be a viable source. Don't steal this from, you know, a friend's social media post or something. It does need to be something that's a viable source. You will go through and talk about these 3 liabilities, whether it's a deep dive of 3 cases all in one space or a survey of 3 controversies or cases, 3 different legal liabilities. And then in your conclusion, you'll be applying what happened in these cases or controversies or what these issues are to your business. So what are best practices that you would have in place? Maybe you have a heat sensor, maybe you have a motion sensor, maybe you have security guards that walk through with, you know, some sort of animal that will have a sense of smell to help identify if people are there that shouldn't be there. Maybe you have 1,000 laser beams pointing in all the different directions in the room where the artwork is, like half of the action films I think I've seen in my life that deal with being in a museum. You know, whatever that is, you're going to talk about based on the 3 different controversies or cases that I discussed earlier. These are going to be best practices that I integrate in to be able to help avoid these risks. You'll submit your assignments via Word document. You want to make sure you're using the word processing program via Word document to both FSO as well as Turnitin. So make sure you're joining the Turnitin class. That's where all your comments are going to be posted. Turnitin, you're going to see a lot of markups. Those are me, just so you know. I get a lot of questions, particularly last night. My online cohort was turning in their final assignments in week 4. I've already received a couple of questions about things that were uploaded and some clarifying points there. Every mark you see on Turnitin is me. I use Turnitin as the equivalent of like a pen on a piece of paper to give you feedback. So make sure your content is on Turnitin. That way you're going to get line by line feedback instead of a more general overarching, like you did a great job, here are a few good tips kind of thing. You'll get really detailed feedback. Now, to approach this liabilities paper, a couple of best practices, some useful resources. Number 1, consider legal blogs. One of my favorites is Hollywood Reporter's Esquire under their business tab. I highly recommend looking at Hollywood Reporter Esquire. You usually will see anywhere from 4 to 7 cases-ish a day that they'll talk about. They will talk about cases across industries. So it's not just like you're going to only see things related to copyright infringement and they'll only be related to television shows that are on a streaming platform or something hyper siloed in. You're going to see stuff across the board. You're going to see all sorts of discussions dealing with contracts, dealing with employment law, dealing with safety, dealing with infringement, dealing with investments, dealing with harassment, you know, everything under the sun. So it's a good place to start, and it's written in a blog news article style, which is usually pretty accessible. In addition to that, I'm a big fan of findlaw.com. Findlaw.com has a great platform with blogs and news articles that you can use this week as well. So that's another great resource, findlaw.com. In addition, you can also use Nexus Uni, and I'm a huge fan of Nexus Uni. Nexus Uni is a really unique and powerful platform. It is a premium service. If any of you need help getting onto Nexus Uni, I'm more than happy to stick around at the end of this session and do kind of a 101 of how to log in. For some reason, logging into Nexus Uni seems to be the biggest trick when it comes to our current work from a distance kind of format. So I'm more than happy to go through and talk you through how to get onto Nexus Uni, as well as go through and do a quick sample search, show you how that works. So Nexus Uni, I'm a big fan. If you're looking for court cases, or even if you're looking for news articles, Nexus Uni is helpful. And then lastly, researching different industry sources. So make sure that these are viable industry sources within your market. Make sure that they're coming from lawyers, from somebody who has a background and can give you true advice, that you're not looking at something that's a little more informally written. For my online cohort, thank you for joining us. We are going to have your first discussion board is an interview that I did with a fellow Chair Emeriti of the Entertainment, Art, and Sports Law section of the Florida Bar when Julie and I sat down, and we actually were just talking last week about that video and the fact that it more than stands the test of time. And we are looking at tying in some of the concepts from negotiation and deal making, from project artist management, talking about best practices to be able to safeguard yourself, working in the industry, avoiding liabilities, red flags as a whole. You'll want to review that interview, and you will want to highlight 2 or 3 takeaways and how you can apply those. Make sure in your response post you include analysis, you utilize the RISE method, and you ask a question to further discussion in that reply. And also make sure you proofread carefully. So make sure you're not going back and editing after Wednesday night for your initial post, but definitely make sure that you review your posts before you hit submit. For my campus cohort, I mentioned it briefly this morning about the Make Your Case presentation. We'll talk about it more later in the week, but you'll want to make sure that you look at the list of Make Your Case cases to kind of preview that list and see if any case on that list really sings to you. If there is a case that just screams your name, you can go on to your discussion board for my campus cohort, and you can post to the discussion board the case name and your name, and we'll double back and talk more about the cases as we move forward this week. But you will be going through and creating a presentation that will be a pre-recorded video where you will go through the facts of the case, the legal issues that the court is reviewing, the court's analysis of those liabilities, and then the final ruling of that case. In addition, you'll find a related case, and you'll also have a couple of questions that you'll need to create to ask your cohort in that video. So as I mentioned, we'll go in more depth, but I just want to give the high level kind of 35,000 foot view of this assignment in case anybody from my campus cohort wants to get a jump start. Knowing that we are in phase 1 of reopening here in Florida, I want to give some flexibility and latitude, because depending on what you may have in your surroundings and your daily life, as things start to reopen, things can change. So I want to make sure if any of you are awaiting word, if you have an ongoing business, or if you're waiting to hear back from an employer, I want to make sure nobody ever got hurt by having too much advanced notice and my time being at the university. So I want to make sure to give you a quick heads up if this is coming down the pipe. So submitting assignments for my online cohort, initial posts are due by Wednesday at 11:59. Final assignments, including final post, are due Sunday, 11:59. Campus cohort, you want to look at those FSO dates. Your assignments will be due at 11:59 p.m. on the dates that are flagged, so look at those dates. In addition, you'll want to make sure anytime you are using 4 or more consecutive words from a source that you include proper quotes and proper citation. And utilize Turnitin.com for support for any citations you would need. Check similarities. Your similarities should never be more than 20%. So if your similarities are going over 20%, go back and look at what's going on, because that means over 1/5 of your paper is not your voice or your analysis. That's usually a pretty big red flag. And then make sure you submit your final assignments on both the FSO and Turnitin. I heard that technology was running a little slowly last night on our platform. So know that if you ever have a tech issue, you have FSO and Turnitin. So if one is giving you a hard time, you can always reach out to the other. In addition, you can always reach out to me. My email is my first initial, which is the letter C, my last name, Willard, W-I-L-L-A-R-D, @fullsail.com. You can also always reach out to me via my Gmail, and I usually have my Gmail open, and they still have that chat feature, which they branded Gtalk, their Google Talk system, their chat system. You can always reach out there. In addition to that, please do not call me at 3 in the morning to see if my refrigerator is running. I'm also known for telling awful jokes, But if any of you would need to reach out, I'm going to put my personal cell phone number in the chat box. If you would need to reach out, that is my personal cell. Might want to ask, please send me a text before you call, because even though I'm really old to be a millennial, I still am a lot faster texting back than answering random phone calls. I get a lot of phone calls for a lot of different things. So if you send me a quick note, students in prior classes can vouch for me. I will text you back typically in like 5 to 10 minutes or less, unless I'm in class. So I'm pretty swift to reply to a text. Just the only thing I ask, don't send messages at weird hours. If you do, I reserve the right to send you a message back at an equally weird hour. But if you email me or message me on FSO, I check those frequently as well. So my goal is to provide you the best support that I possibly can. The world is a wild and changing place minute by minute, now more than ever. So stay safe, be well. Let me know if you have any questions. I will pull down this archive as well and go through and share this with your respective sections. So any questions you would have, let me know. If not, thank you so much for joining live tonight, and I hope you have a great evening for my online cohort. I hope you have a safe and productive week for my campus cohort. Same to you, but I will see you Wednesday morning virtually.
Thank you so much. Take care. Have a good night.
You are so welcome.